second meeting many years ago, for over 3 years ago. And I also am on the Assisted Outpatient Treatment Oversight Committee. So we're going to do something a little differently today. So in the past, when I've done presentations, we've done criminal justice presentation, we focused a lot on law enforcement training, crisis intervention team training. We focused a lot on Laura's Law, and some topics that really have been well covered. There's a lot of new stuff going on in the county, and I thought it would be great if we brought in people who are very involved with reform in our county to talk to us. So first of all, I'll introduce our panelists. We have Vera Bradford here on her birthday. Wow, that blows my mind. And they have years and years of experience, and it would take me till Sunday to read their bios. But Vera has done everything. She taught high school for 11 years, which toughened her up for the court. And she's a head deputy of the alternate public defender's department. Just the public defender's department, got to get her right. She's worked in politics at the Democratic State Central Committee, CTA, the Teachers Association, has taught at Loyola Law School, and for 30 years with the Public Defender's Department. Next to her is Gilbert Wright, who has been a district attorney for over 30 years and has done everything imaginable within that office. I can't read his bio, it's very extensive. But he is the new deputy head of a new department for the Office of the District Attorney. So we now have a mental health unit, mental health division, in our district attorney's office, thanks to our DA, Jackie Lacey. And it is the first of its kind in the state of California, and as far as I know, it's the first mental health division in a district attorney's office in the entire country. So so they showed up on their day off. I'll give you a quick update on our CIT training, because people here are involved in that and are always interested. For the independent police departments, just like last year, we've got 12 presentations scheduled. For the Los Angeles Sheriff's Department, custody and control are down to about 2 to 3 a month. For a while there, we were doing about double that. So that's been cut back a little bit, but we're still involved. In 2017, we gave 94 presentations to sworn officers. In 2018, we gave 44 presentations. We're on track to do about the same as this year, and we are probably involved in the largest CIT training program for law enforcement in the country. So I'm really proud of all of you who do that work. So, that said, I'm not here to bore you with a PowerPoint, but I do want to take you through just a couple of facts. We're going to whiz through this very quickly. This is the most recent PowerPoint from the Office of Diversion and Reentry. And I want to give you a little context and set up some history so you'll be able to understand what's happened. So, my son got arrested in November of 2002. So I've been at this a while. And we pushed our county very hard for reforms, and tried and got involved in training deputies down at the jail. Actually, back in 2003 and 2004, we had our Nami Los Angeles Criminal Justice Committee back then, and that lasted about 2 years. That training, I had hoped, would be continued at the Sheriff's Department, but it was terminated. Things went on. Advocates like myself have been screaming for mental health courts for years and years. We had a series of presiding judges who were not in favor of that pathway. They considered them boutique courts, specialty courts. I've been involved with collaborative courts since 2008. Actually, ever since I met a hero of mine, Judge Stephen Manley from Santa Clara Superior Court. When I was criminal justice chair for Nami, California, during my 2 terms, I served as our representative to Judicial Council's criminal justice collaboration on mental health issues. That was 4 years of work, 20 different judges, department heads in the system at the state level. And they wrote a great report that actually District Attorney Lacey was using to help build her planning. And we had a meeting, and she said, have you ever seen this? And I said, yeah, as a matter of fact, I was on the task force. So, and I'm still working with the Collaborative Courts in California on the Collaborative Courts Justice Advisory Committee. So mental health courts, because our court linkage program, which if you think about it, is sort of creates a synthetic mental health court, saved my son, and it's been a really, really important issue for me for many, many years. In early 2015, the district attorney had a meeting with Terry McDonald, who was then head of custody at the jail for the sheriff's department, and several other people in the county. And Jackie Lacey basically said, we have to change the way we do business with people with serious mental illness. So we're going to, and this is what it takes for change. You know, Nami can call a meeting and we'll get a few people to show up. But when a judge or the district attorney, or, you know, an elected official calls a meeting and convenes the county, it's an amazing thing. Everybody wants to be a part of it, and everybody showed up. Brittany and I, Patricia, we were pinching ourselves when we sat around a table with 50 people where everybody, either the top person in the department or second in command at every criminal justice department in the county was there. And to Jackie's credit, she got the county to start rowing the boat, everybody rowing the oars in the same direction. We met for about 3-4 months. We brought in consultants. We brought in Judge Steve Leifman from Miami-Dade County. You know, we got 2 amazing judges on either coast. We got Manley and Leifman. And we had a big summit. And from that work came a document called the Blueprint for Change, which you can Google and find on the internet. That was the document where the district attorney's department basically said, here's a roadmap for how we're going to change things. Here's a budget. This is what it's going to cost. And presented that to the supervisors. They then allocated $130 million to create the Office of Diversion and Reentry and start building programs. Well, that's been 3 years, and 3 years plus, and we're starting to scale up now. So I'm going to go through this and give you an idea of what we're doing, but mostly I want to have you hear from our 2 panelists, because they're going to give you much better information. So, this. Here we go. So the mission of the Office of Diversion and Reentry is to develop and implement countywide criminal justice diversion for persons with mental health and or substance use disorders, and provide reentry support services to vulnerable justice-involved populations. The goals are to reduce the number of inmates with mental health and substance use disorders in the Los Angeles County jails. That is the charge of the Office of Diversion and Reentry. And also to reduce recidivism, improve the health outcomes of justice-involved populations who have the most serious underlying health needs. That's the charge of the office. And by the way, we'll put out a sign-up sheet, and if you want a copy of the PowerPoint, we can get it to you, so you don't have to take notes furiously, because I'm really going to go through this quickly. So MIST stands for Misdemeanor, Incompetent to Stand Trial, Community-Based Restoration. So to me, the very definition of the criminalization of the mentally ill, which is an old term, is the misclaim. It's somebody who has not committed a serious crime. It's usually a quality of life offense. Normally, if they were to go to court, they'd be discharged from jail right away and sent back to the community. However, if the Constitution says that you have to be competent to stand trial, you have to understand what your lawyer is saying to you. You have to understand what the judge is saying to you. And if you're so ill that you can't understand that, then the public defender, by law, has to declare it out. Correct me if I'm wrong on any of this. And then somebody has to be sent for restoration. But we had no restoration program in the jail. And legally, somebody can sit in jail for 12 months hoping to get better. Thanks to people like Vera, and particularly Judge Bianco, who put a work group together under the Criminal Justice Task Force for Jackie Lacey, we created the MIST Community-Based Restoration Program, and we launched a pilot. And essentially, we're taking people who qualify, taking them out of jail, and putting them in what we used to call an IMD step-down, which we now call an enriched residential services and facilities. And they're receiving treatment. They're no longer in a correctional environment. Treatment helps them become competent. And then the idea is to have them come back to court, have their charges dealt with by the court, and then linked to treatment in the community and permanent supportive housing in the community. So they get well, they have the supports they need, and they don't come back. That's what we're trying to do. Since October of 2016, 846 clients have been removed from the jail and connected to community-based treatment, including outpatient, inpatient, IMD care, and supportive housing programs. Nobody's doing this in California except here in LA County, so I'm very proud of our county. Here's a lot of numbers. I'm not going to read through them, but this is the numbers in aggregate of how many people who have been served since the program started. Now there's also, if you're charged with a felony, you could have a felony and become incompetent to stand trial. And Vera, you want to talk about this? Are you involved with this? Why don't you talk about this? You probably know much more about it than I do.
I'll wait until it's my turn to clarify a little bit about incompetent to stand trial and community-based restoration. But just quickly, once we had our path marked, laid out, and some people who traveled on it in the misdemeanor land, we, ODR, was able to secure funding and housing with cooperation with district attorneys as well. That is to say that they will agree, some often in court, although we sometimes contest these things, that individuals charged with a felony, these are pre-conviction. These aren't individuals who pled guilty. These are individuals charged with a felony who also have been found incompetent. And the goal is to move those individuals out of the jail because they'll wait to get a state hospital bed, because that's where felons, individuals charged with felonies have to go to for treatment. Move them out of the jail before they go to the state hospital and treat them in the community. Because as you know, as family members, that's the only way that we're going to reintegrate our mentally ill or individuals who suffer a mental illness into the community and not recidivate. So that's what it's exactly a parallel to the misdemeanor community-based restoration.
Right. So what happened for many, many years, and under the law, if you're declared incompetent to stand trial and you've been charged with a felony, you have to go to a state hospital. So we're trying to find a way to do that quicker and faster, get people restored much faster. So ODR, Office of Diversion Reentry, also has a housing program. Unfortunately, due to scheduling, nobody from ODR was able really to be here today to talk about the housing, so we have to rely on the slides. But the idea behind this is everybody who is adjudicated is also then linked to treatment and given permanent supportive housing. Because if you don't have a place to live, you're not going to recover, you're not going to get well, and then your chances of recidivating and committing another offense and ending up back in jail, we don't want people to come back. So housing comes along with this, and 1,415 homeless clients have been served by ODR Housing. And they're doing really a spectacular job with that, and working with a lot of other community-based organizations on the subject, like the Los Angeles Regional Reentry Partnership, and a lot of our advocacy colleagues throughout the county. And here's some numbers of clients that have been released to housing, over the years. I can get this to work. And I'm going to sort of fly through this. So we have the Olive View Medical Center inpatient psychiatric unit. We now have a new 18-bed ODR psychiatric unit at Olive View, which opened in July of 2018. So we have a forensic inpatient unit in the jail. That's sort of a LPS designated hospital inside the jail system. Now we are being able to take some of those folks out and get them in the community. Even though they're still in an inpatient unit, they're no longer in jail, and helping them get well. So this is an adjunct to the FIP, to the forensic inpatient units. And we have admitted 42 patients. There's only 40 beds in the jail, with a combination of clients from ODR FIST, NIST, and ODR housing. And 24 have graduated and stepped down to a lower level of care, and the average length of stay has been about 26 days. So, this is a program, I've spent a lot of time on this, but it's an amazing program. The lead program is a partnership between the Sheriff's Department and the Long Beach Police Department, correct?
Yes.
You're involved. Lead
Yes.
Gilbert, you want to talk about lead?
Yeah, and I'm fairly new to this, but I am aware of our lead assisted diversion. We're going to try and start one in Hollywood as well, coming up soon. But what they're doing in Long Beach is the Long Beach police officers are actually going out into the community. Sometimes they have social contacts, sometimes it's through an allegation of crime. And they're making a decision out on the field in conjunction sometimes with the prosecutor that they might call, or the prosecutor may come out to the field as well. And if it's an individual who they think can get treated for their mental illness that they may be suffering, they find a bed for them. They find someplace in the community to take them, as opposed to going into the criminal justice system. And it has been working fairly successfully, from what I understand. So, because it's been working fairly successfully, we're trying to expand it. And the next place I think they're trying to have it is in Hollywood. So it's going to work along the same premise. And it should be noted that a lot of these are social contacts, meaning they see an individual they think might be homeless or might be in distress, and they go and talk to them. It's a new way of policing. They try to determine if they need any help. They try to be not confrontational. From what I understand, they go up to the individuals and they say, "Hey, do you need a bite to eat? You need something?" And that starts a conversation. One thing leads to another. They ask them if they want to go to this place where they get some food and maybe some housing, and they sometimes agree. Now they have to agree to do that, and I believe that there are forms that they have to sign, et cetera, et cetera. So no one is forced to do that. They have to agree, and they've been fairly successful at doing that.
The social workers and specially trained law enforcement officers made a presentation to the steering committee, and I was blown away because they're literally going into very large homeless encampments and trying to build trust, trying to show people they're not there to arrest anybody, they're there to help. What do you need? And they start helping people, and as the people who are homeless in the encampment see that law enforcement is there to help and not make arrests, they're getting more and more buy-in from the community all the time. And these are some of our most challenged and disadvantaged folks, in our city.
And I would just say, it's a different way of policing. We all know what time it is. We all heard the reports around the country and in the city and county of police actions. But this is a different way of policing. And it's been successful in Long Beach, and I think with the model they're setting, I think we can implement this countywide. And at the very least, it'll address some of the issues before they even come into the criminal justice system.
So I'm going to sort of move quickly through, just to let you see the different programs ODR is doing, because I really want to talk about some other subjects today. So there's ODR housing for maternal health and for women who are pregnant and in jail. There is expanding voter and civic engagement of justice-involved populations. I know the ACLU has been really involved in that, going into the jail and registering inmates. The inmates don't think that they can vote. They think they're not allowed to vote, and they are. So they're signing people up to vote, exercise their constitutional rights. We've been involved with Prop 47 in our drug program, reentry and detention case management. So, programs go on and on. They're doing just a lot of new stuff. We don't always get to see that or see all the details. We have a meeting once every 2 months. They're now beginning to form community reentry centers. Suffice to say, there's a tremendous amount of resources being spent. And they just formed the Youth Diversion and Development Committee with another steering committee. We have a Nami member who goes to those meetings, and now they're starting to try to figure out how to divert youth who have gotten in trouble as well. And you already know about CIT and med teams and our mental evaluation teams. So with that, I want to move on. Get to the end now. I want to move on to some other topics because, so the first thing I sort of want to talk about, and maybe Vera will ask you to, excuse me, kick things off. Describe, not everybody understands, the job of a public defender, what your charge is. A lot of times, clients say, you can't talk to my parents, and that puts you in a difficult position because your client is the person who's been charged, not the family. So talk about that, and the job of a public defender who works on these ODR cases, and how has your job changed, really since the Blueprint from Change and the ODR programs have started?
Thank you very much for having us. It's really odd up here because the lights are on and I can't really see you. I feel sort of in interrogation room. So, I just want to take a minute, hopefully it'll just take a minute, to give a little, there are a couple of takeaways. I know that in audiences there's so much information. I want to stress a couple of things. Having moved from criminal running, handling cases from misdemeanor to death penalty cases to the mental health court, over which I'm the head deputy public defender, it has been a really very life-changing experience. And I want to thank all of you. Sometimes I know you feel that the lawyer for your family member doesn't care about you, doesn't listen to you, or you don't have enough information. But I do want to thank you for the momentum and movement and the just persistence of not giving up. For Mark Gale, who's been here for years. We are talking about a program that is solving a problem in our jails. We have too many mentally ill people in our jails. And this is a good thing that we're developing these programs. But I want us to all remember, the goal is that one day we won't be meeting together to talk about solving a problem from inside the jail, because that's what we're doing now. We're standing in the jail and saying, how can we get our mentally ill out? Because the long-term trajectory is, how can we get the right program in the community? Oh gosh, look, my mentally ill family member, or Johnny, who had a fit on the street, or was, and that's why the LEAD program is good, so that when police officers come, the behavior that is otherwise offensive will result in those individuals going to a community treatment and not to jail. So that's our goal, and don't give up. The Office of Diversion and Reentry and the community-based restoration started one rig at a time. Now, so there's that fact. I just want you to remember, keep pushing, don't give up. And keep pushing on this guy right here, because that's the ticket.
You're the ticket.
No pressure.
Yeah. So let me take another about 30 seconds. So when someone is picked up by the police and they're taken to jail, even though the behavior is obviously mentally ill, one might say, they get charged, and then they go to court, and their criminal lawyer sees a complaint, and then they begin to talk to their client or before court, and they say, wow, this person obviously has a mental illness. What should I do now as a lawyer? In the past, by the way, when someone was charged with a misdemeanor, we didn't declare it out. We didn't ask the judge. Actually, it's the judge that declares it out. We ask it. Or the court could do it sua sponte, on their own. We didn't do that. Misdemeanors were nothing, right? We didn't have the internet where everybody could see your convictions. The state of the law in California wasn't so draconian, so that punishments have become so severe. We just pled them out and let them in the community. We didn't holistically look at the person. Now it's different. And I'm not going to spend a lot of time on talking about the history. You probably know that. And so our jails are overwhelmed with the individuals who are mentally ill. So here I am, a lawyer, I'm in the criminal court, I've got somebody that, it isn't just do they know who the judge is. What I try to get our lawyers to remember is, look, you can prop anybody up. Really, we can. If you're a good lawyer, you can get your client to do a lot of things. And I can get them to plead guilty and move them out. The real issue and the test of competency, am I together? Can I be rationally assisted by defense? Can I rationally meet the terms and conditions of probation? That's a key. If I find that my client, I know that I can plead him guilty, but as soon as he goes through that door, oh, he's just going to go on the streets. He's going to act out again because there's no mental health treatment or there's a co-occurring disorder. Okay, so the definition of incompetence has expanded. So as a lawyer, we really examine that now. So therefore, in the mental health court, first of all, once the client is found incompetent, and Mark, you stop me when you say, okay, if you're going to move on, that's fine. Okay, once my client, I know now that is incompetent, every single misdemeanor in this county comes to the mental health court. It doesn't stay in the criminal court. They all come to us. And then we do, as many of you know, and I can tell you later if that's important, how the track goes there. When the Office of Diversion and Reentry came about, thanks to Jackie Lacey's committee, a steering committee and the lots of meetings, now we have a group, county agency funded, that says, you know what, let's get these people out of jail. This is a jail, you know. They're in cells. If you haven't, I know you haven't, because family members aren't allowed to cell level. I could tell you and describe pathetic states of individuals. You take a mentally ill person and you put them in a cell, and it's cold and it's dark and it's dank and people are yelling or there's law enforcement there. They don't know why they're there, so it's disgusting. Just, there's no words that I can use. Many I guess I could use. In any event, now we go in, ODR finds housing, they find a program. They identify with us who's a good candidate. Let's get them all out. The goal is to get every single misdemeanor out of there. They shouldn't be there in the first place, and so we're going to try to get them all out. So that's how that happens. We get periodic reports and so forth. Okay, now you call the lawyer now. You know they're in the mental health court. You call the lawyer and you say, hi, my son John is here in your court now. I'd like to talk to you. He's a lawyer, I'm his lawyer. And I need you to tell me what's going on. And I need more information. And in fact, I have a power of attorney. I have a power of attorney, and I therefore have a right to the arrest report, and I have a right to see his records, and I want the doctor's reports, and I want to see all that. The fact of the matter is, the powers of attorney, I just want to share this with you because families get so frustrated, have no significance, weight, or authority when it comes to someone who's charged with a crime. They just don't. Because the laws of confidentiality between a lawyer and a client are trump that. Believe it or not, and I know you know this, but of course you could believe this. Many clients, as Mark said, they'll say to us, I don't want you to talk to my mom. I don't want you to tell my mother anything. Now this can be in a fluid state of psychosis, this individual. But the lawyer then has to navigate these things. Or the lawyer doesn't want to share with a family member a doctor's report because then something that might be confidential could get passed to Gilbert. And there's not all the liaison feds are like Gilbert. Understanding of what those documents have. We have a duty because this case may well go back to the criminal court. So all those sorts of, it is a pressure, I think, on a lawyer. They want to assist. They want the information from you. That said, many lawyers, we should know how to talk with you. There never should be. And we're working on the training, experience, tweak the perspective of our lawyers as well. When you get a lawyer that won't talk to you, or you're just very frustrated, you could always, in the mental health court, you always can call me or send me an email, because we're really working on that. But I also want you to understand that even that lawyer that doesn't talk to you is doing their level best for your child, really. That's why they are there. So I want to assure you of that. So that's how that process goes, and the same so is it also with felonies. And then there's just one last thing I'd like to touch on. And that's just really quickly, I think Gilbert, we'll talk about diversion. When the Office of Diversion and Reentry began, we didn't have the new obvious diversion law. And the diversion law is different than the diversion that we talk about here, the concept was. Because those cases will come right out of the criminal court. They can also come out of the mental health court. And they will be pre-conviction, and they will be able to be treated in the community. And so I just wanted to clarify that.
In fact,
yeah.
The diversion that you're talking about here is sort of a misnomer because everyone pleads first. They plead to a crime. to get into ODR version that we call it. When we get to the subject about the Assembly Bill 1810, Penal Code Section 1001.36, we're talking about pre-trial mental health diversion. They don't have to plead to anything. They don't have to plead to anything. I don't know, do you want me to just go into it now, or?
Well, I want to ask for one quick thing, and then we'll move on to that. I can get my mic to work. Okay, so working? Okay, so I've been coaching families for 16 years on what to do when their families get arrested. Wrote the little brochure. And tell me if I'm doing the right thing. So Vera told you there's lots of reasons that the lawyer can't talk to you, but the lawyer can listen. And I've always told families, ask whether it's a private attorney or the public defender, what do you need from me, the family? I'm the person's father. What do you need from me that can help you defend my son? How about, now mental health history is something that's very, very important. So what I tell families, especially if your loved one's getting in trouble consistently or being hospitalized consistently, have a running Word document, updated every 3 months, every 6 months. Long letters and sagas to the judge don't really get anything done. But the lawyer needs to know who your loved one is. They need to know the diagnosis, the medication, who their doctor is. Maybe the attorney wants to talk to a doctor, I don't know. But I want them to have that information. So I want to provide a psychiatric history to the public defender, and then it's the public defender's job to decide whether to use that information in court or not.
Yeah, exactly.
I hope I'm giving good advice.
No, that's great. Is this on?
Yeah.
No? Yes. Exactly. And be persistent in that. It's okay. You could provide documents. I see you shaking your head, so I know you probably had a negative experience. And be happy to hear and try to develop that and work on it. Because we make mistakes as well. And there are lots of individuals that we're trying to work with. I do want to say something. So therefore, Mark is right on the mark. Mark is right on the mark, and don't give up. The other thing I want to remind you is, and it's this. Although we're pushing forward with how our police agencies view the behavior of the mentally ill, we are not nearly where we need to be. And so, in your communities and through Nami, if there are other measures that you can take, besides calling the police to have them intervene, because I can't tell you the number of stories we have that families needed help. They call the police to think that an individual might go to a 5150 hold, to a facility, and they land up in jail. I can't tell you. We had a great story from a woman who came to Jack Tracy's in the steering committee. Her husband was a captain. And they said, oh yeah, it's okay, just put your son in jail. He'll be okay. We have a mental health treatment center there. Just pick him up, put him in there. And the mother was concerned. They called, they did. Well, that young man hung himself. And so I know that everybody wants to say we need our police, and trust me, I know that. But I just want you to think about that and be careful and cautious about what you do. And I'm glad to continue your question when you finish over there.
So it used to be, in other counties, whereby if you wanted to get the jurisdiction of your loved one's case moved to a mental health court, and you were in a regular criminal court, they would have to transfer jurisdiction to that mental health court. In LA,
No, it is transferred.
it is transferred? And in LA, we have a court linkage program where they had caseworkers in courts to help advise the DA and the judge about resources that could be brought to bear. Gilbert's talking, I wanted to preface your discussion on 1810 because, as Gilbert said before, there would have to be a plea, and then the court linkage program would try to connect somebody to treatment.
That's for ODR.
Right, yeah.
Not for 1810.
Yeah,
Right.
well, I just really want to clarify something too, so you understand this as well. When someone is found incompetent, the criminal case is suspended. Jurisdiction, as we would call it, transfers If the client is moved to the, if the patient inmate is moved to the mental health court, and that's all misdemeanors and all felonies pre-conviction, and even in the criminal court, if it stays in front of the same judge, the criminal case is sitting in a box. It's like in purgatory, it's in a cabinet. No one can deal with that. Nothing can be done. And that's important for you to remember that, so that the level of frustration you might feel. That's the first thing. The second thing is, some family members want to hurry up and get their family member back into the criminal court. And so, Gilbert's going to plug his ears up when he hears it, but hurrying the process is not advantageous to someone who is mentally ill. Trust me, if the person becomes stable enough, they will go back. But moving them quickly to get them back is just not that helpful. So just remember that as well.
So, before I turn it over to Gilbert, he's got a bunch of several subjects to talk about. Quick little history. Is James Curtis in the room? Not here. So James Curtis is one of our Nami members. We're at an advocacy council meeting, and we're talking about what do we advocate for, because now we've got open communication with the district attorney's office, because we have a district attorney that will listen. And he had been a prosecutor in a prior employment, and he said, you know, because we all agree that there's a need for specialization in the courts for mental health. We want public defenders well-versed in mental illness. We want district attorneys and judges well-versed in mental illness, so they understand what the challenges are. So Curtis had an idea. He said, well, let's have a little box. There's when the police officer writes a report, it goes to the district attorney's office, and there's somebody called a filing deputy, and the filing deputy decides what charges are going to be filed. He says, what if we put a little box on the form that said mental health? And then the DA's office will process that differently with an element of specialization to that. But we brought that idea, and basically we're told that logistically that would be almost impossible, but we brought the idea in. And sometimes, you know, you plant seeds and you water them, and you're not sure when the plant's going to grow. So just recently, then we hear that our district attorney, Jackie Lacey, is going to form a new mental health division within the office of the district attorney, as I said in our opening, and introduced me to Gilbert, who's going to be the head of that. And frankly, that's about all we know so far. This is that new. So with that sort of context, I turn it over to you to Gilbert. Talk to us about how the committee formed, what your charge is, what the work's going to be doing, the involvement with AB 1810.
And I too want to thank you for allowing me to be here. Before I say anything, I do also want to, I can't say enough about Jackie Lacey and the fact that she created this unit in charge and gave me, put her trust in me to try to make sure with her vision, we could try to do some great things in the county. What I can tell you at bottom is what we're trying to do is try to, when we can, get as many people out of the criminal justice system and into some community housing. Now, as you'll see, we're not always going to agree which people should be allowed to do that, but that is the charge. Because I don't know if you've heard from Jackie Lacey, her mantra is, look, you should not be punished for your mental illness. And whenever we can, try to make sure that someone who needs to get the type of treatment that's tailored to their specific mental health issue, that's what we want to do. We also have to be concerned about crimes that are committed and other things that I will bring up. So, because of what Mark had said and the blueprint for change that I'm sure you've all heard, ultimately our mental health division came about. Our mental health division was created in January 2019. What we're doing in our mental health division right now is we have subsumed our alternate sentencing courts downtown. We have several alternate sentencing courts where one has to plead to get the benefits. They have to plead guilty to get the benefits of what that specific specialty court can give you. We have Women's Reentry Court. We have Veterans Court. We have several other courts. not coming to mind. ODR is the main one, but right. But before that, we had alternate sentencing courts before ODR in 2016. And their charge was to try to get people out of the criminal justice system, get them into a veterans program or something of that nature, to try to make sure that their specific mental health needs are met. So we've subsumed those courts downtown. We've also subsumed the ODR court that you've heard a lot about. Our deputies handle that court. We've also subsumed the psychiatric section, what Vera was talking about, a mental health court, where people who are incompetent to stand trial, a doubt has been declared. We have deputies handling those courts and trying to determine what's the next steps for individuals in that court. I should say that when we're talking about missed and when we're talking about felony incompetent to stand trial, remember the thing in those situations is you are taking a person, putting them into the community, trying to restore them to competency, then they come back, as Mark said, to handle their case if they become competent. That could mean they have to go through a trial. That could mean the case gets settled. And they continue on with the kind of program that they're in. The good thing about these programs, and I was talking to someone in the community the other day, not only do we want to get people out of the criminal justice system, we want to treat them, we definitely want to make sure that after their case is over, they still have access to some of these programs. And that's what ODR is trying to do also. They stick with them, they try to they try to come up with interim housing and try to take them to places where they can get jobs, and that, in the hopes, will try to prevent them from thinking about trying to recidivate. But we also now are in charge of the pretrial mental health diversion, and that's what I'm going to talk to you about right now. That the pretrial mental health diversion came about out of AB 1810 and the penal code section I just mentioned to you. Remember the distinction between pretrial mental health division and all of the other courts I talked to you about is that with pretrial mental health division, diversion, you don't have to plead guilty to a crime. So theoretically, the defense could move for a motion to have consideration to go into the pretrial mental health diversion right after the charge has been filed, or right after the arraignment, or right before the preliminary hearing. And the requirements to get into the requirements to be considered for that is the defendant has to suffer from a mental illness. It has to be a recent diagnosis. The mental illness has to be a significant contributor to what caused the crime. The defendant has to agree to be placed into pretrial mental health diversion. The judge has to agree that this person would get benefits from the mental health diversion. And then the kicker, not the kicker, but the thing where prosecutors are going to be looking at, and the defense is going to be looking at, and probably where you're going to see Vera and I disagree, is that the judge has to make sure or feel good about that this individual is not going to pose an unreasonable risk of danger to the public. So, with that, those are all the factors that we have to look at. This is a defense. The defense has to make the motion for the individual to get into the pretrial mental health diversion program. And once they do that, then that's when everything starts to get triggered. They'll get a mental health report. If you share it with us, if you not share it with us, we have to determine whether or not, based on the individual's background, criminal history that we look at, the circumstances of the crime that was committed, and other factors, whether or not we're going to agree or oppose. You should know, even if we oppose, that does not mean the person's not going to get pretrial mental health diversion. It is up to the judge. So even if we object, the judge could agree over our objection that this individual should go.
So some cases, you're gonna require a plea?
No.
No, in some cases you're not, depending on.
Well, no,
the case.
if
I know
a
it-
if a defense makes a motion to go into pretrial mental health diversion, there is no plea.
Right.
There is no plea. So, and as Vera has told you very well, I've known her for a few years, and Vera's brilliant. And seriously, I am about to bring the knife down the back, but no, Vera's brilliant. Everything she says is absolutely correct. Her duty is to her client. The public defender, the defense attorney, your duty is to the client. Our duty is, every time when I'm talking to younger prosecutors and anybody out in the community, I always tell them, when we walk into the courtroom, we always say we represent the people of the state of California. That means we represent everybody. We have to ensure that the defense gets a fair trial. We have to ensure that the victim's rights are heard as well. And we have to ensure that the crimes are being punished appropriately. So Vera and I may disagree on an individual who is in pretrial mental health diversion, because we might say this person might pose an unreasonable risk, because remember, they are not going to a jail facility, they're not going to a custodial setting, they're going into the community, they're going into a community housing. So we have to try to evaluate as best we can, is this person, given what we know about them, given what we know about the crime that was committed, given what we know about their criminal history, whether there are certain types of convictions out there, given their social context, is this individual going to be, is this individual going to pose safety issues for other individuals that are in the community housing where this individual is going? So I don't know if we want to talk about that. I think what Vera said is, I think she's right about the misdemeanors. There are very few misdemeanors that I would say that I can disagree with Vera about. They should all be in pretrial mental health diversion or community housing or out of the criminal justice system. There are certain crimes, though, we have to be concerned about. So we might disagree on driving under the influence. We might disagree on domestic violence cases. We might disagree on crimes where even those charges of misdemeanor where somebody was injured. So I don't know if we want to address that.
So say, the public defender is asking for the 1810 kind of diversion, and the judge decides, no, this person's not eligible for that, for the reasons you talked about. So then what would happen? You go to the old school diversion where you do
Theoretically, they could try to do ODR.
Okay.
Go ahead.
No, I was just gonna say that.
So if that's the case, then all the panoply of options are available, as Gilbert said. But also, there, by the way, is a diversion when 1001.36 in the penal code was passed. There's also 1170 where if an individual is found incompetent and they're in the jail waiting to go to state prison, they can be diverted as well. But, so that's an option. Once the pretrial diversion does or doesn't work, it may well be that that individual is incompetent as well and then the whole track. It's just it's another, everything else, then you just kick in, just like Gilbert has talked about all the other options that are there.
Right, and this would also occur with somebody even if they were competent.
Yes,
Yes.
yes, but mentally ill, but have a
But
mental
have a
illness, yeah.
serious mental.
Right.
And it's important to note that the distinction between ODR and pretrial mental health diversion is with ODR, the person has to be homeless and suffer from a mental illness. AB 1810, pretrial mental health diversion, you just have to suffer from a mental, I don't want to make it sound like it's easy, but you have to only suffer from a mental illness. You do not have to be homeless. in that regard.
So, for what I've heard in meetings, a lot of this activity is clustered in certain courtrooms, downtown and metro, you know, because these are the high volume courts that are really impacted, a tremendous amount of cases. We're gonna take questions at the end. And,
Correct, Mark, but I have news.
oh, you have
I
news?
just went to, we had a meeting yesterday with the
Alright, go.
supervisor. Oh, so you already knew that?
No, I don't,
We are now, it's now going to be expanded countywide. There are going to be hub courts, hub ODR courts.
Yay.
really?
Yeah, there'll be a court that's going to serve, that's going to be an area that's going to serve Long Beach, Compton, Torrance, and some other areas. There'll be a court in the Valley of Van Nuys that's going to serve San Fernando and some other areas. Downtown will take Pomona and Pasadena and some other areas. Lancaster, that is part of the county, I know. They will have their own program. We're going to try and start this in April of 2019. So yes, as before, it was just downtown,
Right.
and a lot of good stuff was going on downtown. But now hopefully that stuff can.
This is really exciting news, because one of the questions we've been asking is, well, what if you're not in that court? You know, if you live in the San Fernando Valley and live somewhere else, you don't have, you don't have that kind of access. So you can see we're trying to build diversion and treatment and housing for people with mental illness, competent and incompetent, you know, around different circumstances. But in all, what do we want? We want people to recover, get the help they need, get the housing they need, adjudicate the case to its fair conclusion, and not come back.
Now, before there was ODR in 1810, I believe just about every other courthouse in the county had some type of alternative sentencing court. But it's certainly not like what it is now, so I would.
Okay, so we've got a little bit of time left. Are there any, you want to raise your hand? Go ahead.
If a person has been charged, a homeless person has been charged with a misdemeanor for possession, and they qualify for your pretrial diversion, how does that reflect on their record? Will it be still the misdemeanor, or will it be something else?
Go ahead.
Well, I was going to say, if in fact the individual is diverted before they enter a plea, it's the diversion where you go right out of the community pre-plea and they complete it, that case will be dismissed.
And if it's ODR way, and they successfully complete all their terms and conditions, there are ways to get that record expunged, if I'm not mistaken. And there was one thing I forgot to say with pretrial mental health diversions.